Right, I see we have Lady Justice Macur and Lady Justice King and all counsel. So, Ms. Rogers, please begin your submissions.
Thank you. Our starting point, as the court knows, is that the judge was right, that there isn't an error of law, that she carried out a balancing exercise and reached a conclusion which she was entitled to reach. And for this court, that is the kind of exercise with which the court will not generally interfere. The references to the test is so well known to the court. I wasn't going to go to any of the authorities. They're set out in footnote 1 to our skeleton argument, which is on page 2, as to the approach. And on that basis, we said that the appeal should be dismissed. In terms of our submissions today, the court obviously has our written argument. I'm not going to go through that, but we do rely obviously upon it. And just to say this, in terms of the position of the child, we are deferring to the what the guardian is intending to say on in relation to that. I've had the opportunity to speak to Ms. Bottrell beforehand, so it may seem risky to adopt something before someone says it. On behalf of the local authority, we're adopting what is said by the guardian in relation to the child. That said, unless the court wants me to take a different course, I was going to start with the basis of the application and the nature and the basis of the application. In terms of access to documents under the rules in family proceedings, I think it was suggested that there isn't a rule. There isn't much in the rules, but in the Family Procedure Rules 29.12, sub-rule 2, there's provision for anyone to have a copy of an order made in open court. And that is the roughly equivalent to the position under the Civil Procedure Rules in 5.4c, although that goes wider. Under 5.4c, one has access to not just to the orders, but to the claim form and statements of case, but not exhibits. Now, under CPR, going back to the FPR, under 29.12 sub-rule 1, that's a rule in relation to documents on the court files. Unless it basically says, except as provided by this rule or any other rule, no document or copy document filed or lodged in the court office shall be open to inspection by any person without the permission of the court, and no copy shall be taken or issued to any person without such permission. So there is a rule in relation to access to documents under 29.12.1, which basically requires the permission of the court. As I say, that is focused on documents filed or lodged in the court office, and it anticipates that the person who wants access goes along to the court. Of course, it's made slightly more difficult at the moment because the relevant court offices are closed, and I understand that applications have to be made either by email or in writing, and they go into a system, but they're dealt with in the normal way. But you can get from the court orders made in open court as of right, no difficulty. Anything else you have to ask the court for. Now, that's the position under the rule. Now, so far as the inherent jurisdiction of the court is concerned, we accept that goes wider than documents which are filed or lodged in the court. I'm going to come back to Dring, if I may, but in terms of the inherent jurisdiction, essentially it's in relation to documents that relate to the court proceedings. And going back to the point that was made this morning about what's in the files and what files are we talking about, if I can refer the court to Mrs. Justice Roberts' judgment at paragraphs J27 to J9, that's where she refers to what, effectively what documents we're talking about. And the judge, of course, had in the files for the hearing before Mrs. Justice Roberts, we did have the indices themselves, so it was actually easier to follow when you got the documents. They of course could be provided, but that explains the documents which were before the court at various stages. They're summarised, as has been pointed out already, at the paragraph 114 of the judgment. Core bundle, page 69, and that's because it had been submitted that the documents that were on the indices, that were showing on the indices, could be categorised in that way, essentially moving from the more confidential and private at the top to the less confidential at the bottom of that list. And to draw the court's attention to paragraph 115, where after that list, the point that the categories of documents from 1 to 4, whenever the subjects of orders requiring material to be filed on the official court record, they appear in the indices as a result of a direction from the court requiring the local authority to secure records from third parties involved and to serve them and so on. And that's how they came to be produced. So those are the documents that we're concerned with, and we don't contest that if one's looking at the inherent jurisdiction, those documents would fall within the inherent jurisdiction.
Ms. Rogers, could I just ask you two questions before we move on from that? First of all, at paragraph 115, the references to the indices, which Ms. Brooks has referred to also, they were prepared as a result of a direction from the court in this application.
I don't believe so. I believe that there were indices which were prepared essentially in the ordinary run of events for each hearing. So there would be indices for hearings, and the key ones were before His Honour Judge Hess, His Honour Judge Levy, and the Court of Appeal on the appeal against His Honour Judge Hess. So those had been produced or provided to Ms. Newman, and that is the source. I was going to take the court to the other document. I don't know whether the court has looked at the schedule.
I have, and I want to ask you about the schedule, but just going back to the indices. They appear in the indices as a result of a direction from the court requiring the local authority to secure such records from the third parties involved and to serve them on all parties to the care proceedings.
That's not a reference to this application.
All right. It's just I've not come across in care proceedings local authorities. I don't know if my Lady Justice Macur has. I doubt whether the Master of the Rolls has. But local authorities being told to produce indices of that type in the course of ordinary care proceedings. You're on mute, Melanie.
I don't read that as being a direction from the court that they produce indices. I read it as being a direction from the court that they produce the records, and that's having happened. They are then they then appear in indices for the court bundles. And my junior, who is a family lawyer who deals with care proceedings, is indicating that that's right.
Could someone do us just a really brief note so that we absolutely just bottom this out, because the last thing we want it to do is it have to be put right later. So then my second question relates then to the schedule, which is in the supplementary bundle at page 33.
Yes.
Now that was completed by the applicant, and then now this is a Scotch schedule as I understand it. and maybe some reference to the indices.
I'm so sorry,
We're getting quite a lot of feedback, and I think if everybody mutes, not talking.
Can you hear me
I'm
now?
sorry. Yes.
Now, the document, I'm not going to begin to go through it, obviously, but I did notice when I looked at it before court that the response of the local authority in a number of places says not prepared for proceedings, not prepared for proceedings, not prepared for proceedings. I'm looking, for example, at page 53, where 3 of the items are recorded, numbers 85, 86 and 90 are recorded as not prepared for proceedings, which I think led in part to my confusion when I was discussing matters with Ms. Proops this morning, because I couldn't understand, if that was the case, how it was being said that everything in the indices was part of the court file. Or that the local authority had accepted that it was all part of the court file and therefore could be dealt with directly by way of the inherent jurisdiction, as opposed to an application under the Freedom of Information Act.
I think can I leave the question of the Freedom of Information Act to one side for a moment? This schedule effectively is a list of the documents extracted from the indices. So it's the indices transferred into form, and when the response is identifying what the document is, it's not suggesting it didn't appear in the index to a court file. But those sorts of marks are that they were not originally prepared for the court proceedings. So that they are communications which took place. I think that the example on page 53, emails between the solicitors relating to foster carers, were in the course of the arrangements that were being made at the time. They then are gathered together and they are placed in an index for a file which goes before the court or is prepared ready.
This takes me back to needing to understand how precisely in what context these indices were created, because I just find it very difficult at the moment to understand how a lot of these documents would possibly fit within however much you expanded definition of court file in the drink sense.
Yes, they are, yes. But the fact that these documents were in files to which an index was prepared in the context generally of the court proceedings is where they are. But while just on that schedule for a moment, in terms of what's requested, just to note that one has the request from the appellant, and just to note on SB 34 that the documents are requested to be disclosed by the local authority. So in a sense, that's a part of the inherent jurisdiction question, is whether the court is open justice isn't just about the court producing documents. There's a question which the Supreme Court advert to in Dring of the extent to which the parties can be required to facilitate the open justice principle. And in terms of the responses to the schedule, there are a number of items where the simple word no appears, and that means that there's no objection to the disclosure on behalf of the local authority in terms of Miss Newman having access to it, and so one can see that there are a lot of objections that are made, but there are also aspects where the local authorities had no objection. Similarly, the Guardian, and just to indicate this, that in terms of what is required in an exercise like this, when there's effectively a blanket request for anything that's in any file and recorded recorded in any index, is that it does require time to be taken by the local authority or any other party to consider whether it can simply be handed over or not, or whether there are objections and what kind of objection they are. So it is a time-consuming and demanding exercise which is being carried out in this case. But we'll deal, if we may, with as you mentioned, suggest with a short note, which we can agree.
Please.
Obviously, we'll pass it past the appellant's team before submitting it. But I suspect it's more for Miss Fottrell and me, or specifically Miss Early, to sort that out, and we'll do that. And just in terms as well, the point was made that the judge hadn't read the documents. That's quite right. Our submissions to the court, and this is in paragraph 41 of our skeleton before the judge, but just for reference, it's supplemental bundle 1, page 83, was that we suggested that dealing with it in that compendious way, by having it categorised and then looking at the specifics of the schedule, was sufficient for the court to deal with it. And it wasn't suggested by anyone that the judge should have read the papers in order to decide this matter. And of course, had the judge wished to do so, the documents would be made available. So that's where this is, not strictly an application under the rules, but an application under the inherent jurisdiction. But before going to DREAM, which I do promise to do so next, it's important, we say, to put this in the context of family proceedings. And as the court's already noted, that there is an ongoing transparency review under the care of the President, which was announced last year, which has been taking evidence, and I think is still taking evidence. And it's very important that that should be the case, because there are stakeholders of all kinds with an interest in these issues. And it's right that that should take place. What one has seen over the last, I was going to say 20 years, it's probably longer, is the kind of adjustment between openness and privacy. I won't call it secrecy, but the privacy of the kind of proceedings which take place in the family court day in, day out. There may be people's marriages, there may be civil partnerships between individuals, there may be private law matters relating to a child, there may be public law matters to a child, all sorts of matters where the intensely personal, the intensely private family information is dealt with by the courts. Now, the importance of transparency and confidence in the system has led to the various changes that we've seen. And under now FPR 27, I think 11, journalists, accredited journalists, which essentially means journalists who are in possession of a UK press pass, and there's a procedure which identifies who can get the UK press card and how they get it. Those kind of journalists can be admitted to proceedings, and the courts are familiar with having journalists come into court and to follow the proceedings. But following the guidance that was issued when that change was brought about, one can see right at the outset that it was recognised that would lead to journalists wanting access not just to proceedings but also to underlying documents, and that's flagged. One can follow it through the guidance. In AF6, Authorities File 6, tab 6, this early will give me an electronic page. I'm afraid I've gone old school and I've got paper. It's 16. I'm told it's 16 electronically, my lord. One sees the question of access to documents being raised at paragraph 11, which is on the second page of the document. The change to admit media representatives to hearings in family proceedings is likely to give rise to a number of issues related to the discretion by all levels of court. It is likely that courts will quickly be faced with applications for the provision of documents to media representatives present in court to enable them the better to follow the substance of proceedings. I emphasise that because this is part of the core aspect of open justice, to be able to follow the proceedings. And then if minded to grant the application, the court will need to consider the terms of any restriction relating to use and so on. Then that's picked up in paragraphs 15 and 16, which are quoted in the appellant's skeleton argument. Again, just to draw attention to in a sense, in paragraph 15, to the second aspect of open justice, promoting better understanding of the working of the family court. For such purposes, access to court documents is not generally necessary or desirable, having regard to their confidential nature. So this is where it starts. We're not suggesting there's any sort of fixed point where things are fixed forever. The journalists get access, but they don't automatically get access to documents. And reading on to paragraph 20, what's contemplated in 20 subsection 2 is where a representative of the media in attendance at the proceedings applies to be shown court documents. The court should seek the consent of the parties and then subject to appropriate anonymity and restrictions on onward disclosure to see such summaries, position statements and other documents as appear reasonably necessary to a broad understanding of the issues in the case. And then if there's objection, it's basically recommended that the matter should go up to the High Court. And of course, it's important to bear in mind that we're in the court. Obviously, we're in the Court of Appeal today. Matters are dealt with in the High Court, but matters are also dealt with in lower courts up and down the country, day in, day out, dealing with matters of this nature. So that was the guidance originally. The updated guidance in 2011 is the next tab, which is tab 7, page 20 of the electronic. And this deals with media access to court documents and sets out general considerations at paragraphs 31 through to 40. I'm not going to take time on that now. Essentially, it's recognising the issue and the open justice questions that arise without, in a sense, resolving them. And then there are a series of paragraphs where the court, looking at specific types of family proceedings, looks at the question of what the position is on access to documents. And if I could ask you to look, just by way of example, at paragraph 90, internal page 23, electronic 42. All it says about access to documents in relation to children public law cases is a reference to Rule 1273. If an order is made in open court, any person may obtain a copy on payment of the prescribed fee. That's where we were in 2912. And similar, going on to paragraph 94, access to documents dealt with there. And then perhaps I could just give the references. It's followed through at 100, 105, 109, 112, 116 to 117, 120, 128 to 129. In other words, it's been flagged as an issue, but what we do not see in the guidance is that the journalist will get a right to, certainly not a right to access the whole file, and in terms of what you can get, it appears to be rather limited. And in effect, that's where the guidance stops in terms of access to documents. There's guidance in tab 8, which is about anonymising judgments, which I don't need to go to. The guidance in tab 9, which is the 2019 guidance, this is the guidance that was issued by the President, having been foreshadowed in the reporting restriction order in this case. He promised that he would issue guidance. He did issue guidance in May of 2019. That was consulted on. What we have in the file is the final guidance as issued on 2019. It does not deal with access to documents. I'm not being critical in that sense. It simply hadn't arisen as an issue with this focus. The only reference to access to documents is on the 4th page in 8E, electronic page 779. This is in the context of varied reporting restrictions, I should say, and any documents disclosed to reporters are covered by the provisions of the Administration of Justice Act Section 12 and Section 97 of the Children's Act 1989 and remain confidential. So it's implicit in that that journalists can get documents, but it doesn't say anything about what you get or how you get them. The reason for mentioning this is to just underline the importance of looking at this, the question of access to documents, in the bigger context of the family procedure rules as a whole. Looking, of course, we're concerned today only with a public law family proceeding of a particular type, but in terms of the wider issues, this isn't the only case of this nature before the court. Applications will be made, it can be anticipated, in other cases, and it is highly desirable, we say, that the question of access should be looked at afresh in the context of the transparency review. Now, that's all I was going to say about the rules and guidance. It's emphasised on Miss Newman's behalf that because she had access to the proceedings, if she had turned up, she would have had access to a lot of information. Obviously, she would have heard what was said in open court. Sorry, in the course of the court proceedings, not open court, as the proceedings went on. But we do not accept that she would have got access to the file either before His Honour Judge Hess or before His Honour Judge Levy. It would have been a rather remarkable thing for the court to have ordered. What one sees in the cases is effectively journalists getting what you need to follow the case. And I'll give just one example from the authorities. In the case of Webster, this isn't the Webster you've seen, it's the second judgment at appeal file, I've got 12, something like that. Appeal file 1919, and I think it's electronic page 407, and it's paragraphs 41 and 43, where the media had been allowed to attend, and what the judge releases is the position statement, which had been put before the court, which the judge described as being a model of its kind at paragraph 19. And so in that context, the judge said that the position statement was needed. It had been referred to extensively in the course of the hearing, but not read out in full. And therefore it was essential for the media and through the media, the public, to understand what went on, what took place. So that we say is the kind of document that the media, having got access to the proceedings under Rule 2711 as accredited media, would be able to get if they turn up at a hearing. That takes us, I think, nicely into Dring itself. And obviously the Supreme Court case, we say is important in looking at the nature and extent of the inherent jurisdiction. Of course, it was not a family case, but the President of the Supreme Court, Baroness Hale, is no stranger to family law. The importance of the principles and the approach is that it is said to be essentially applicable to all courts and tribunals. So one can take it as a starting point. What is said about the open justice principle in Dring, Miss Proops has already taken the court to paragraph 1 and indeed to paragraphs 40, 41 through to 43. And the way in which the court explains or refers to the well-known, hugely important open justice principle is effectively restated in very clear terms by the court. Now, I do not have a note that you were asked to read paragraphs 45 onwards. They have been highlighted in the file, so you may already have read them. They are important. Perhaps rather than read them, would it be sensible to have a look at the paragraphs now, and I'll wait while the court reads.
Yes, we will. Thank you.
19:46. It's on it. All right, so I'll pick it up a bit.
Yes.
It's important that the way it's framed there is that the court has power to allow access, but the applicant has no right. The person seeking access has to explain why they seek it and how granting access will advance the open justice principle. And it's important that this application is effectively made under the inherent jurisdiction and under the open justice principle. And that being the case, Dring is the guiding principle. And one has to ask, how does this advance the open justice principle? It's not suggested that it's needed in order to understand what the court has done. Or indeed how the court is working. What it's essentially being used for, and of course one's not critical of a journalist seeking information. That's what they should be doing, but it doesn't follow that the journalist seeking information means that they're entitled to it under the open justice principle. It's not about, this is not a right to a journalist who is pursuing a story, a possible story, or who wishes to find out a story, to say there has been a court hearing, there are documents in court files, and I want to see them all in order to see whether there is anything of public interest that I should be reporting beyond what I can see from the court records themselves. So it would be, in our submission, a massive extension of the open justice principle and of the approach in Dring to grant access to everything in the court files. One hesitates to cite first instance decisions on the facts to the Court of Appeal, but the fact is that Dring 2, the court, that this matter was sent back to the judge by the Court of Appeal, and it was dealt with by the Honourable Mr. Justice Picken in a judgment which came out after the end of our hearing, but before Mrs. Justice Roberts gave her judgment. It appears in the authorities' files at 39. We deal with it in our skeleton at paragraph 11, and I wasn't proposing to go back to go over that. So it's important to note that the request originally was essentially for all the court files, including documents in a court file that was a file of all the disclosed documents, as opposed to the documents which the court actually used when it was dealing with the hearing. And that application for the disclosed documents was abandoned when it went back before Mr. Justice Picken, and it was focused on a smaller set of proceedings, and even that was not acceded to. So the fact that something is in a court file does not mean that you can get access to it under the open justice principle. Essentially, the court does is, if one sees Mr. Justice Picken carrying out essentially the same exercise that Mrs. Justice Roberts did, taking the balancing factors into account, looking at the specifics of the case, and deciding what was required in order to advance the open justice principle. That's a key part of the case. In terms of I should say before leaving Dring that paragraph 47, of course, draws the attention of the court to the practicalities and proportionality of the request. It is important. Ms. Proop suggested that it would be a sorry thing if one looked at practicalities. In our submission, it's not. It's important as part of the overall exercise that one looks at what is involved. And of course, to remind the court of what the Supreme Court says at the end of the Dring judgment in paragraph 51, which even in the context of the civil procedure rules, they urge the bodies responsible for framing court rules to give considerations to the questions of principle and practice raised by this case. That's Supreme Court recognised the need for that. We invite this court to recognise the need for that. And that is something that's undergoing within the transparency review, which is specifically about access to and reporting of court proceedings, information court proceedings, family court proceedings. Two other small points, but in relation to open justice, it's right that the Supreme Court adopted the approach of the Court of Appeal in the Guardian News and Media case, GNM in our skeleton. It was referred. It is an important case. In our submission, the way in which the principles are explained by Lord Justice Toulson, having had regard to comparative law and across a number of jurisdictions, is extremely helpful. He comes in paragraph 85 to a default position, which where a document has been referred to and relied on in open court, there should be a default position in favour of disclosure to journalists. Even then, it can be outweighed by countervailing factors. And that's exactly the approach that's carried forward through into Dring. But it's important to note that GNM was not a wide-ranging application. The request for documents in that case was for specified documents which had been referred to but not read out in the course of the proceedings in open court. The reference to that, GNM is in Authorities File 2066. The relevant electronic page is 693. The relevant page of the judgment, and it doesn't have a paragraph because it's before one gets to the judgment, is page 621 at H, where that is recorded. The journalist had followed the extradition proceedings. They'd been in court, precisely as my Lord Justice Voss had said. This is what happens now. We're working in paper and documents aren't read out. And where reference is made, the journalist needs to see the document in order to understand what's being said in court, and that's the basis of the process. It's important we say that that's part of the exercise where one's dealing with proceedings in open court, that there has to be a focus, not on everything that's in the files before the court, whatever they may be, that you're looking at specific documents and saying, why do we need them? Appreciating that it's very hard to do that exercise if you don't know what's there. But what you can see and what the court is referring to, what you need to see is an exercise that you can carry out and need to show why you want the documents. That's what happened in GNM. GNM, extradition proceedings in open court, DRING, civil proceedings in open court. One has to question whether it's quite the same when one looks at family proceedings which are taking place in private. And the Poppy Worthington case, which I know that two members of this court were party to the judgments in Ray W, which is Authorities File 29, the President, McFarlane, referred to the default position, in a sense, being the other way in relation to proceedings in private, and it's at paragraph 36 of the judgment. The default is you're in private, with power for the court to go into public or to modify the transparency, but through the various moves of transparency that have been. But it's been a process, a step-by-step process of opening up. So the default position which one has in DRING, which we had in GNM, may not be quite the same in relation to child proceedings carried on in private. And when I say not the same, it would be surprising if it were a wider access under family proceedings than it is in other types of court proceedings. One has to look, in short, we say, at the facts of the specific case, and that again is what the judge said. In terms of practicalities and principle, we do, of course, essentially we say one comes to the res balancing test, paragraph 17 of Lord Justice Staines' judgment, sorry, not Lord Justice, Lord Staines' judgment in the res case, which is very familiar, cited in many cases. We've set it out in our skeleton at paragraph 15. You've got competing rights under the convention. Neither has as such precedence over the other. Values in conflict intend to focus on the comparative importance of the specific rights claimed. The justifications for interfering with or restricting the right have to be taken into account, and then you've got the proportionality exercise. There's very familiar, of course, to the courts. That's a part of the human rights jurisprudence. It's what courts do as public authorities, perhaps not every day of the week, but very, very frequently. And that's what the judge did in this case, was do that, carry out that particular balance. In terms of the role of the journalist, it's important to know that we accept, of course, that reporting on matters of public interest is an important aspect of life in a democratic society under Article 10. No challenge about that. But the question is, how far does it go in a case like this? if you are a journalist and you've got a legitimate intent, does that mean that you can go to court and say, I want to see everything in the file, just because I've got a proper interest in matters of public interest in relation to the underlying proceedings? We submitted a short note in response to the question which came by email yesterday. I wasn't going to go through that unless the court wants us to, because I think that when one's looking at the role of journalists in Article 10, one looks at what's already in place, and that the Freedom of Information Act 2000 is obviously an important measure, not just for journalists, it's for any individual, anybody who wants to make requests for information, and public authorities have a duty subject to exemptions to comply with it. It's all very interesting, all of that. There's the extent to which there's a right of access to information freestanding under Article 10 is also jolly interesting. But in terms of what this appeal is concerned with, and not wishing to shy away from what is a very interesting debate, none of that matters when the application is said to be put on the basis of the inherent jurisdiction of the court, in effect under the open justice principle. So we can put those other considerations to one side, focus on what it's said to be, which is the inherent jurisdiction of the court, effectively when documents are in relation to court proceedings, and therefore one looks at the open justice principle and whether access serves, and to what extent it serves, or how it serves the open justice principle. And we say that this is precisely the exercise that the judge carried out in looking at the balances on both sides. In terms of where the local authority sits with this, I should say that we're grateful for the observations by Lady Justice King in relation to the role of the local authority in this matter, and what was said about the judgment of His Honour Judge Hess and the appeal that was allowed by the court. I think it's Court of Appeal 1, where the Hess order was overturned. The role of local authorities in relation to these matters is obviously a very important one, and they carry out difficult tasks day in, day out. And as the judge rightly noted, local authorities are hard pressed. We've heard reference to the fact that there are strains on resources of journalism. Yes, we know there are fewer journalists who are able to go to court. In fact, one of the oddities of the pandemic is it probably makes it easier for people to follow court proceedings because one can live stream or get access through the internet. There are resources challenges here, but it's important to emphasise that the local authority has tried to be constructive in the approach to the application that was made. As I've noted on the schedule, they identified documents which could be handed over without any difficulty, identified the documents where there were issues, and that it has still been a time-consuming and costly exercise. There is concern that a successful application in this case, this is not the only case. Any case involving children and families is going to be an important case involving serious issues. There are rights of individuals, children, parents, foster carers, employees, experts, third parties, documents coming from police, documents coming from the National Health Trust, documents coming from documents and so on. A lot of material is being gathered. And if a request is made for access, it will be required to be considered carefully by those involved. And it is a burdensome exercise. It's a time-consuming exercise. And it is a factor in considering where this will go. This does cause my client concern as to the consequences of allowing access to journalists. Just on the simple, well, it's in a file, there is a court proceeding, you're accredited, there are serious issues involved. The approach of Mrs. Justice Roberts to that, we say was a nuanced and right one. One can see from her immensely careful judgment going through the categories of documentation that were laid out, and she actually responded to the schedule. There's a yes/no box that she completed the Scotch schedule. I don't think we've got the version which has her comments in it. The order, the schedule to the order reflects what she considered should be handed over. And the court has that schedule. Part of it did not have to be redacted, part of it did have to be redacted, and that's an exercise again which was carried out by my client, and it did take it actually took longer than we'd anticipated, but anyway that was carried out. I'm not going to go through the documents in supplemental bundle 2 for obvious reasons, but it's important to note what is now available to Miss Newman, which was not available before, from which we would say there is plenty of information there, which enables her, and it would enable anyone interested to see what had happened at court and to track how this matter developed. I don't want to refer to the documents in detail, but one sees, following the orders of the court, which the court orders identify what the key issues were for the court at each stage, and they change over time, and focus. And one can see through the orders what the approach was of the parents, of the local authority, of the guardian, and the positions are stated. There's a good deal of information in those documents, perfectly intelligible. It's suggested, I think, in the skeleton that it's so redacted as to make no sense. We reject that. That one can follow, and I think as an outsider to the proceedings, I have followed through supplemental bundle 2 what went on, and reading as one can the judgment of His Honour Judge Hess, the judgment of the Court of Appeal in relation to His Honour Judge Hess, the transcript of the proceedings before His Honour Judge Levy. There's a great deal of information there, which is absolutely clear about what has happened, and supplemented by what's in SB2, puts the matter, absolutely serves the open justice principle in the right way. So that in a sense brings me back to the first point, which is the judge was right, she did a good job. There are 3 points of appeal, all of which have been advanced by Ms. Proops. We responded to them in our skeleton argument. I'm mindful of the time I've already taken. Unless the court wanted me to add to anything that's in the skeleton on those points, I wasn't proposing to do so. And unless Miss Early tells me I've missed something, which she very kindly tells me I've not, I was going to. It's going to stop like this. It's safe to say that there was one, in terms of looking at what the judge did, in terms of looking at the mother's position, the references that were given to the court were paragraphs 125 to 130. In fact, the judge, of course, returned to that point in paragraphs 169 to 170, when she briefly refers to the Al Maktoum decision, which had been handed down, again, before the judgment was handed down after the hearing. So it's just to note that was an extra reference in relation to the mother's position. So subject to the outstanding point about the files, which we'll deal with, unless there's anything the court wants me to deal with, those are our submissions.
Well, Ms. Rogers, in paragraph 158, the judge says, in circumstances where I would be unlikely to permit the publication of this information in any media article, I can see a principal reason to elevate her wish to read the material over the importance I attach to M's Article 8 right of confidentiality. Do you think that it was acceptable for the judge to prejudge what she might or might not do once the material had been read and looked at in relation to a media article that might be written by a journalist in the future?
I quibble with the word prejudge, if I may.
I think put against you.
Yes, I don't accept that it's prejudging. The court, I absolutely accept the point, and it's been said in a number of courts of high authority that judges are not newspaper editors or broadcast editors, and there are different editorial considerations. And the court should be, the court in terms of deciding what a journalist would want to see, as opposed to, is not, journalists decide what they want to see, and courts can't say what a journalist wants to see. But the court is not being asked here, and Mrs. Justice Roberts wasn't being asked to rule on an application to publish. But it would be, in our submission, completely unrealistic to not have an eye on what was likely, and the judge leaves it open. If it's unlikely to be published at the end of the day, if it's unlikely to be any permission to be granted at the end of the day, that is a factor we say that the court can take into account. We don't accept that that's prejudging it.
Well, but on one sense, it's arguing backwards, isn't it?
Yes. Yes. On the basis of documents that no one's seen.
Yeah.
But that is true. But in terms of getting off the ground, permitting someone to access this information is of itself something which requires justification. I mean, we mentioned Imam and Cengiz in our written skeleton, and I don't necessarily to go to that. That is an intrusion of itself, but it would be. I don't think, in answer to the judge isn't going too far there, particularly in the context of a case like this, where the journalist, with respect to Miss Newman, not identified a wrong that needs to be exposed. What she wants to do is read everything. She wants to see what's there. That's what the basis of it is. And there's a sense that's what
it's not completely fair, because her position is that there was a wrong, and it's just a question of looking at the material that shows how that wrong occurred.
Shows further than she already knows how the wrong came to be. But in a sense, the absence, it's an absence point. But I don't want to paraphrase what was in the Court of Appeal judgment about what was wrong with the judgment of His Honour Judge Hess and how that had all come to pass. True it is. I'm not suggesting that there's nothing. That there was an order which was overturned by the Court of Appeal. So it isn't a case where everything ran. There was nothing that had to be altered or nothing had to be reviewed. I'm not suggesting that at all.
No. Okay. And anything else then, because we are running up against time?
Not for me, thank you, Lord.
Lady Justice Macur? No. Well, thank you very much, Miss Rogers. I think probably we'll take the break now before we come to you, Miss Cottrell, but we'll just take 5 minutes till 4 minutes past 3. Thank you. Well, I think we're all back, so we can invite Ms. Fottrell to start her submissions. Thank you.
Thank you. May I just start by signposting where we would like to take the court in terms of our submissions, and it may come as some relief to know that I intend to be brief, and I hope that I'm able to be brief. First of all, to remind the court that the Guardian has filed quite a detailed skeleton argument, and you'll find that in the core bundle at CB 153. And I don't intend revisiting the detail of that skeleton argument, but I'd like, if I may, to deal with 4 issues. The first is to make some brief general points about the position that the Guardian takes in this appeal, but also the position the Guardian took in the court below. I know the court will be familiar with those, and I'll deal with that matter relatively swiftly. The second point I'd like to deal with is to signpost elements of the judgment that we would invite the court to look at in terms of the way in which the appellant puts her case, because our global submission is aligned with the global submission made on behalf of the local authority, that Mrs. Justice Roberts' judgment was not wrong. It is not one which this court should overturn, that she undertook an evaluative exercise and that she did so correctly. And so we'd like to signpost some aspects of elements of that for the court to focus on in terms of looking at that question. The third point I'd like to look at, if I may, in a little bit of detail, is the point made by the appellant that this is essentially a case about the exercise of parental responsibility, and that Mrs. Justice Roberts has erred in the way that she has assessed that in the balancing exercise. And then, if I may, I would just like to make some brief points about the matter raised by my Lord the Master of the Rolls at the conclusion of Ms. Rogers' submissions in relation to the observations made by the judge at paragraph 151. So beginning, if I may, with the position of the Guardian, the court will know, and I make these points simply in response to some points made by the appellant, that the court will know that the Guardian was appointed in this case with the agreement of the parties to the case, and she was appointed to represent the interests of this particular child. I would reiterate a point which is in the judgment, which reflects the position that the Guardian took in the court below, and that is that the Guardian is not interested, as it were, in making points of principle, and she's troubled by any suggestion that this case could be used as a vehicle for points of principle. The Guardian's role in this case is to represent the interests of this particular child, and in doing so, the Guardian has focused on where this child's best interests lie. It is right to say that the Guardian was first appointed in these proceedings in 2015, and she represented this child through the proceedings up to the point where she became the subject of a care order, as you know, in March 2017. There was a brief period when the Guardian was not involved in the case for personal reasons, but she also represented the child through the proceedings in 2018. She took the decision in terms of her analysis of the child's best interests in this particular case that it wasn't appropriate for her to see the child in order to assist the court with that analysis. And she did so for a appropriate and child-centred reason, that she took the view that this child had been through the trauma of the proceedings themselves, but also the life events which underpinned the proceedings. And she thought it was inappropriate and unhelpful that she would revisit the child in order to assess and identify her welfare best interests. In our submission, that doesn't in any way negate the value to the court below, or indeed the value to this court, of the analysis that the Guardian undertook. And it may be right to say that there are some general points made in the Guardian's analysis, but they are valid points in relation to this particular child. And they were points which assisted Mrs. Justice Roberts in her analysis of where the child's best interests lay. The other point that I would make in relation to the Guardian's position is that she emphasised throughout the proceedings in the court below, and I know the court will understand this point, but it is central to the submissions that I will make on behalf of the Guardian and on behalf of the child. The Guardian emphasised that this child enjoys her own right to respect for her private life. And when the court undertook its analysis in the court below, as we know and as is uncontroversial, it was required to undertake a balancing exercise. And prominent in that balancing exercise is the child's right to respect for her own private life. So those are the points I wanted to make by way of introduction. May I then move on to the second point that I wanted to address, which is the judgment of Mrs. Justice Roberts. In our submission, it is very telling that at the conclusion of the submissions of the appellant this morning, the appellant struggled to identify what it was that is wrong with the judgment in the court below. And that in itself, we say, puts this appeal in jeopardy. Because if my ladies and my lords look carefully, as I know the court will, at the judgment of Mrs. Justice Roberts, and if I may, I'd like to signpost a number of elements of it. It is a completely model exposition of the law. It is a model in terms of identifying the competing interests and the competing rights in this case, and the balancing exercise is undertaken by the judge in an evaluative way, as she is entitled to do, and the appellant struggled to pinpoint where the judge had gone wrong in relation to any of those three matters. Dealing first of all with the judge's analysis of the law, the court will know that that is set out in very comprehensive detail from paragraphs 21 to 73. Pausing there, if I may, for a moment, the submissions that were made by the appellant this morning tracked the judge's analysis of the law from paragraphs 21 to 73. In other words, the cases that the court was taken to this morning by the appellant are cases that the judge considered. Those cases being Webster, Re-W, the Ward case, the Re-S case, and the Re-B case. All cases which Mrs. Justice Roberts, in the context of paragraphs 21 to 73, considered. And it's also relevant in our submission that there was much common ground between the parties in the court below, and there is much common ground between the parties before this court as to what the applicable law is. Returning then to the judgment of Mrs. Justice Roberts, she begins her analysis and discussion at paragraph 111 of the judgment. And again, in our submission, that is an exceptionally thorough undertaking by the judge. The general analysis goes from paragraphs 111 to 130, and within that, the judge correctly identifies the rights with which she is concerned and the balancing exercise which she is to undertake. We would particularly invite the court to focus on the analysis that the judge undertakes from paragraph 123 through to 130. And I'll return to that in a moment if I may, because from paragraph 123 to 130, the judge is dealing with what we understand to be the crux of the appellant's case, which is that this is an exercise of parental responsibility by the mother, and the court should be reluctant to interfere with that. And I'll come back to that if I may in a moment. But returning to the judgment, at paragraph 130 onwards, the judge then picks up each of the individual categories of documents which Ms. Newman is seeking to be disclosed to her for access purposes. And in relation to each of the classifications or each of the categories of documents, the judge undertakes a thorough analysis of why the child's right to private life is engaged, balancing that against Ms. Newman's rights in relation to each of those classifications of documents, and reaches a conclusion in relation to each of those classifications of documents. And that, as the court knows, is an exercise which takes the court takes Mrs. Justice Roberts to paragraph 159. We are struggling, for our part, to see how it can be said that when one looks at that judgment, Mrs. Justice Roberts was wrong. And as we said earlier, the appellant struggled in her submissions to identify, and particularly in answer to questions from the Master of the Rolls, what is wrong with the judgment. We say that at the end of the submissions from the appellant this morning, we understand the appellant's position to be that the court correctly referred to the parents' views in the court below, that being the views of Q, that she recognised the respect that should be accorded to these views, that she undertook a balancing exercise, and as part of that balancing exercise, she identified the competing rights of the child, the mother, and Miss Newman, and she undertook that balancing exercise in accordance with her discretion. The focus of the criticism is the weight that the judge attached to particular evidence, and as was pointed out to the appellant in discussions with the court, that is an exercise which this court should be very reluctant to interfere with. May I then move on to deal perhaps in a little bit more detail with the question of the exercise of parental responsibility. The jumping off point in relation to this, in this particular case, of course, is as correctly identified by Mrs. Justice Roberts, that the court is exercising its disclosure jurisdiction. And the repeated submissions that are made and the suggestion that there is a public interest being served by the journalist having access to documents is one that Mrs. Justice Roberts accepted. But of course, the default position is not a position of access. And that is clear from the fact that repeated authorities, all set out in the judgment, properly identify that the disclosure exercise is one which must be undertaken by the court. When the court is exercising its disclosure jurisdiction, as I said before, and is clear from the judgment of Mrs. Justice Roberts, the court does that by reference to the competing rights of the parties, and it does that by reference to the balancing exercise. It's helpful in our submission to look at the way in which the judge dealt with the case on which much reliance is placed, namely the decision of A and Ward, which is a decision of Lord Justice Munby. And you'll find this in the authorities bundle at tab 21. It is paragraph 135, which I'd like to take the court to, which is electronic bundle, page 490. Now, much is made, or much was made.
Sorry, Ms. Foxwell, could you just tell me the paragraph number again, please?
Of course, paragraph 135. And this is where Lord Justice Munby deals with the issue of the disapplication of Section 12 in relation to the parents in the case of Ward. Now, we would ultimately invite the court to read from paragraph 135 through to paragraph 141. But if I may, I'd like to just signpost a number of key points in these particular paragraphs and in the analysis that was undertaken by Lord Justice Munby. In terms of the facts in this case, it is right to say that in this case the parents sought permission to disclose documents to a journalist for the purposes of discussion and publication. And it's also right to say that there was no objection raised in the case by the guardian or on behalf of the child. And that is important for the following reason, that when Lord Justice Munby came to undertake the balancing exercise, which he does at paragraphs 138 through to 139, he did so on the basis that there were no competing private interests. So if the court looks at paragraph 138, having looked in the previous paragraphs at the fact that the individuals with parental responsibility wanted to disclose the information, making his own observations as to whether that is wise or foolish, and then going on to say, having reached that point, the question then becomes whether the balancing exercise, that is, striking the balance, and I'm at paragraph 138, as between, on the one side, the private interests of the Ward family and the various public interests they can pray in aid, and on the other side, whatever other private and public interests are involved, comes down in favour of lifting Section 12. And then he goes on in paragraph 139 to consider how that balancing exercise should be undertaken. And at the top of the following page, he makes the point that the balance here in the Ward case is not, as may often be the case, a balance between differing and conflicting private interests. It's essentially a balance between, on the one side, the private interests of the Ward family and various other public interests. Now, that case was considered by Mrs. Justice Roberts, in this case, in the court below, and Mrs. Justice Judge Roberts begins her consideration of that at paragraph 67. And you'll see at paragraph 67 and 68 that she sets out those paragraphs that we looked at a moment ago. And then she returns to it in her discussion and analysis, in particular at paragraph 127 and 128. And you'll see that she distinguishes this case from the Ward case because, unlike the Ward case, the competing interests here were not simply the right of the family unit, but also the individual members of the family unit. And the conflict arises, the judge says, in this case, because the evidence before her from the guardian is that the rights of the mother and the rights of M do not coincide. Also, tellingly and of fundamental importance, we say, is how the judge deals with the direct evidence which she receives in this case from the mother. Now, Ms. Proops, in her submissions this morning, sought to place great significance on the fact that the guardian was unable to provide the judge with up-to-date evidence, and the direct evidence came from the mother. And you can see the judge deals with that at paragraph 124. At paragraph 124, the judge sets out in some detail the email she received from the mother. And there are a few points we would highlight for the court's attention here. First of all, the mother says, in regards to maintaining the privacy of my daughter and her family, this is now unachievable. And she goes on to say that's as a consequence of documents having been published, and concludes that paragraph saying, hence the matter of protecting M's privacy and human rights is now beyond repair. And then she goes on to give the judge evidence on which the judge places considerable weight, that the child was in private counselling as a consequence of the trauma that she had experienced. And then she goes on in the last paragraph to say that she hopes that lessons can be learned, and she sets out there having verbalised a wish that her case could be utilised to benefit others. Now, one has to look at what the judge says at paragraph 27 about that evidence. And what is striking in our submission is that that evidence informs the judge's decision about the detriment to M of her private life being invaded by the disclosure and the access to documents. So in paragraph 27, the judge records that the mother's email tells her that this is a child who has been severely traumatized. This is a child who is vulnerable. That the child is so traumatized that she requires therapeutic intervention. And she also records the fact that the child's age and the possibility that the child has been exposed in discussions with her mother about the detail of the proceedings, and perhaps the mother having projected her own views onto the child. Those are matters which the judge was entitled to take into account. And as I said a moment ago, they informed the judge's analysis of where the child's best interests lay. But what she also goes on to say, which is fundamentally important and which fits with her analysis of the Ward case, is that in expressing, I'm not expressing views of more general application. I am dealing with this child in these particular circumstances. And at paragraph 28, she provides further detail as to her view of whether the mother's wishes, as expressed in the email, are conclusive. She deals with that further at paragraph 129, and she reaches her conclusion at the bottom of paragraph 129. It is difficult in our submission, and further we say that the appellant has failed in our submission. It is difficult for the appellant to sustain a submission that the judge was wrong in relation to that exercise. She was entitled to undertake it, and we say she undertook it with some care. And the way in which the judge addresses the distinction between this case and the A.N. Ward case, we say is flawless, because there are differences between the A.N. Ward case. And as I said a moment ago, our understanding at the conclusion of the appellant's submissions was that the appellant accepts, and this I don't think was the position in the court below, but the appellant accepts that the parental responsibility and the exercise of parental responsibility is not the end point. The court is entitled to identify the child's right to respect for her private life, and the court is required, we say, to undertake that exercise. Those were the points that I wanted to make in relation to parental responsibility. May I then go on to deal with the final point which I would like to address, and that is the point raised by my Lord, the Master of the Rolls, with Miss Rogers, as to paragraph 158. And there are 3 points I would like to make about paragraph 158. The first is that insofar as the judge is making an observation as to what she may or may not be unlikely to commit by way of publication, she is making that observation only in relation to the children's social care assessments. And the court can see, if you go item by item, the judge deals with each item separately. So it's wrong to try to characterise that as a general point that the judge is making. She's making it only in relation to the social care records. But the second point I'd like to make in relation to that observation is the reason why the judge reaches that conclusion is that she takes account of the fact that much of the detail of what is in social services assessments in relation to this child, and much of the detail that is in social services records, is already in the public domain as a consequence of published judgments. It would be artificial in our submission, and it was our submission to the judge in the court below, it would be artificial for the judge to completely ignore the possibility that access is being sought with a view to publication. We don't accept that the judge conflated those two issues. She had an eye on those issues, she had regard to those issues, but she didn't conflate them, she dealt with them separately. The third point I'd like to make, if I may, is of course it's important to look at what she actually says. She doesn't close off the possibility of publication. What she says is, in circumstances where I would be unlikely to permit publication of this information in a media article, and then goes on to say, I can see no principled reason. And so I'm afraid our submission is that the points made by the appellant in relation to that are decontextualised, and this court has to be very careful in terms of accepting a reductive submission that indicates some sort of prejudgment on the part of Mrs. Justice Roberts. May I also just signpost one other matter? In the postscript to this judgment, in which the appellant invited the judge to look at the case of Al Maktoum, the judge revisited some of the points that were made in relation to parental responsibility and dealt with those issues again. And it's not our submission that Al Maktoum was a case about exercise of parental responsibility, but insofar as it was, those matters were addressed by the judge. So, my Lord and my ladies, those are the points that we wanted to make on behalf of the Guardian. In conclusion, our submission is that Mrs. Justice Roberts got this right, and that this court should not overturn her judgment. May I pause there for a moment and just check, if I may, with Mr. Wilson to see if there's anything that I have forgotten, and of course with my Lord and my ladies as to whether there's anything you wish me to address that I haven't.
Lady Justice Macur first. Lady Justice King.
No, thank you.
Those are my submissions. Thank you.
Ms. Crooks.
The first point I perhaps need to deal with is the suggestions made by Ms Rogers that there may be documents that actually fall outside the court's jurisdiction. All I can say about this is that this is news to us because that's not how matters were put below. There's no evidence before the court on that issue. It's been raised first time on appeal, and I invite the court to proceed on the basis it is a non-issue in this case, and that, as with the court below, this court should proceed on the basis that all of the documents in issue do fall within the court's jurisdiction. Moving on to Ms Rogers' submissions on the 2009 guidance, it's very important that that guidance is now 11, 12 years old. It's very important to have an eye to the emphasis that has continuously been placed by the courts on the need to avoid a frozen approach to court practice in this area. It's a point that's alighted on by Lord Justice Toulson, as he was in Guardian News at paragraph 80, approved by the Supreme Court in Dring at paragraph 12. And importantly, in the 2009 guidance, the President is not addressing the specific circumstances that arise in this case, which is what is to happen when there has been no journalistic access to the hearing, where there has been no achievement of open justice. How is the court to approach the question of access, journalistic access to documents in those circumstances? Ms Rogers went on to make a point that journalists who attend hearings would typically be entitled to see position statements in family court proceedings. Well, the first point I'd make about that is we haven't even been provided with those documents. And it can't be right that in a case where there has been no immediate attendance at the original hearing and therefore no open justice, that debars our access to those types of documents that Ms Rogers acknowledges we would have been entitled to see had we been present. And it's very important, and this is a point that neither of my learned friends can get around, that when journalists attend family court hearings, their access to the underlying information concerning the child is not confined to the position paper, because they will inevitably hear wide-ranging discussion of all of the evidence concerning the child, notwithstanding its acute confidentiality and sensitivity. Moving on to the Dring case, Malone Ms Rogers relies on Mr Justice Pickens' judgment in that case, the remitted hearing. I suggest that that judgment does not remotely assist this court in determining whether Mrs Justice Roberts lawfully approached the balancing exercise in the case that was before her. Dring was not concerned with a request for access to documents for public interest purposes. It was concerned with access to documents being sought on behalf of potential claimants against the backdrop of there having been a 6-week open court trial. So whatever conclusions Ms Justice Pickens may have reached in that case, they tell us nothing about what the correct approach was in this case. Ms Rogers effectively took the court to Mrs Justice Roberts' judgment and said, see, she's striking the balance. She's considering both sides. That is not the issue. The issue is whether she had an impermissible, unlawful, skewed approach to the conducting of the balancing exercise, both when it came to assessing the extent to which there would be an unwarranted, untoward interference with M's privacy rights, and when it came to assessing the implications for Miss Newman's Article 10 rights if a relief was refused. It is not enough to simply point to the judgment and say, look how much balancing work she's doing. Miss Rogers next went to the Guardian News case and made the point that in that case, the scope of the application was far narrower. I make a number of points about that. The Guardian News case was, like Dring, a case where the journalists had been able to follow the case because it had been heard in open court, which naturally enabled them to make a more selective request for documents. Nonetheless, the application actually went quite wide because the documents included all the affidavits, all the witness statements, and the underlying correspondence between the US Department of Justice and the SFO, even though, as I say, the journalists had already been able to attend the hearing and hear much of the evidence on those issues. Crucially, in that case, it was not a case where the person having effectively responsibility for for the person whose interest would be most seriously affected, was positively supporting the application. In the guardian case, the relevant person whose interest would be affected by the disclosure was the US Department of Justice that was objecting in strong terms to the application being allowed. Notwithstanding those objections, access was permitted. Our case is, of course, very different, because here we have the parent, the person legally responsible for the child, positively supporting journalistic access to the relevant documents. Ms. Rogers goes on to say, well, Ms. Newman's actually seen a lot of documents telling her what happened in this case. So we want to be absolutely clear about this. Ms. Newman has no source materials that tell her how matters unfolded in respect of M, the child in issue in the proceedings, beyond the judgments and the local authorities' highly limited case summary and a smattering of court orders. The only other source documents that Ms. Newman has seen is medical reports that concern the mother, from which all of the information concerning the child have been redacted. So it's simply wrong to say that we have a lot of source materials that enable us to see the full picture. Even if you say this application was too wide, which we say it's not for the various reasons I've outlined that include that it's fully supported by the mother, that doesn't mean that the court was just entitled to dismiss the application for relief. The question becomes, well, what relief ought to have been granted? And the simple point we say is that insofar as Mrs. Justice Roberts has allowed us a form of relief, it is altogether too nugatory. And just pausing there to draw your attention to the 2011 guidance, which is at tab 30 of the authorities bundle. Sorry, it's not tab 30, I'm so sorry. It's tab 7. It's page 30 of the electronic bundle, tab 7. And it's paragraph 37 of the guidance. So this is 2011, nearly a decade ago. We see reference being made to a case of XYZ, where the former president said he would like to see a practice develop whereby expert reports are routinely disclosed to media representatives, and media representatives made able to comment both on the reports and on the use to which they were put in the proceedings, as long as this did not undermine the child's anonymity. Well, we haven't been given access to the expert reports or to the underlying witness statements. On the question of the court's prejudgment at the publication stage, I'm afraid neither of my learned friends have any good answer to this point. Ms. Rogers rightly concedes that the court shouldn't trespass on the journalist's editorial decision-making, but that is precisely what the judge did in this case. Ms. Rogers said, well, the judge left the issue open. That is not a fair characterisation of the judgment. The judge concluded that on the balance of probability, she was unlikely to permit publication. That finding clearly, fundamentally inflected the entirety of her reasoning when it came to how the balance should be struck. That was not a reason, that was not a conclusion that was open to her for all the reasons I've already explained. It amounts to plainly impermissible bootstraps reasoning. It is a fundamental error of law that takes the entirety of the judgment. Then we move on to what is probably the core issue in this case, which is the role that's played by the responsible parent as against the role that's played by the children's guardian. Now, I do invite you to look quite carefully at what is said in the Weller case about matters effectively when it comes to the privacy rights of the child being seen through the lens of the responsible parent. To like effect, Reclos in the Strasbourg Court of paragraph 41. The real issue in this case is whether, when you compare this case with Ward, a different outcome should have been arrived at in this case as compared with Ward because of the objections of the children's guardian, because this is the principal point that's taken against me in respect of Ward, which is in that case the children's guardian wasn't objecting. But that raises the really important question about whether there is any substance to the guardian's objections, to which we say as follows. Ms. Fottrell has said that the guardian took a decision at the time not to meet M for child-centred reasons. Well, there's no evidence to that effect before the court. But let's put that point, that procedural point, to one side. Even if that was a good reason for for the guardian not meeting M, we are still left with a situation where the only person who has given direct first-hand evidence of M's state of mind and her attitude towards the application is the mother. It is, in any event, not enough, we say, to dislodge the primacy of the responsible parents' views and their choices as to how M lives and how she exercises her privacy rights. It's not enough, we say, for the guardian to rely on generalised assertions not rooted in how matters actually stand vis-à-vis the child in question. All the more so when those general assertions can't be stacked up against the evidence and the facts of the case, which include that a considerable amount of information concerning this child is already in the public domain, including medical information. That the application is concerned with access to documents by a journalist who, had she known about the hearing before His Honour Judge Hess, would have heard extensive discussion of the underlying facts and evidence concerning M, notwithstanding the traumatic nature of the proceedings for the child, because one has to assume that the child was already traumatised at the time that the case before His Honour Judge Hess was unfolding. Would the guardian have objected to Miss Newman attending the hearing in front of His Honour Judge Hess because of concerns about the privacy rights, of the child's privacy rights? Well, there's no suggestion that she would have done. There's no suggestion that objection was taken to journalists attending the hearing in front of His Honour, the remitted hearing in front of His Honour Judge Levy, notwithstanding that, yet again, extremely sensitive and detailed information concerning the child would have been discussed. So what then is the principled basis for objecting to Miss Newman accessing the documents that reveal much the same information? Answer: there is no principled basis for that objection. And what that means is there is no proper basis for dislodging or failing to dislodging the primacy of the views expressed by and the choices made by Q, the responsible parent in this case. And we come back to the concerns that I expressed earlier about undue state paternalism in this area. Even if you're with Miss Fottrell in terms of saying, well, okay, in terms of the judge's evaluation of the impact on M's privacy rights, we actually don't think that that can be impugned. That still leaves my second and third grounds, because this isn't a case just about the child's privacy rights. We're all agreed about that. It's a question of balance. And even if there would be some, let's say, undesirable degree of interference with M's privacy rights, you still have to weigh that against the enormously powerful public interest imperative in enabling media scrutiny of this important case, which unfolds against a backdrop of serious concerns being expressed about a lack of adequate transparency in the family courts in general and in public law cases before the family courts in particular. And the truth is that much of the arguments put against me is focused on the child's privacy rights, with precious little argument put against me in respect of my grounds 2 and grounds 3. So for all those reasons, we do say that this is a case where the judge went wrong in her approach to conducting the balancing exercise in this case. It was an approach that was skewed and paternalistic in nature and resulted in a conclusion that cannot be reconciled with my client's fundamental Article 10 rights that are undoubtedly engaged in the most intense manner in this case. So for all those reasons, I maintain that the judge went fundamentally wrong in law and her judgment cannot stand.
Lady Justice Macur. Lady Justice King. Well, thank you very much to all of you. Before we conclude, we've had a request from one of the journalists present, Alice Twait, asking for clarification that she may share the skeleton arguments on the reporting restriction order with those of the Transparency Project with an editorial role and responsibility for publication to her trustees in order to ensure the accuracy and compliance of the reporting restrictions order in relation to any more detailed reports she may wish to make of the proceedings. Do the parties have any submissions they want to make on that request?
No, my lord.
My lord, only this, I'm sorry, there's no concerns about the skeleton. Obviously, the only restriction was pending the appeal hearing starting, as far as we're concerned. So far as the RRO is concerned, it appears that the copy in the file before the court is not the final order. There are a couple of paragraphs missing. The parties have emailed this morning about to try and sort out the correct order. It's obviously important that Ms. Twait and indeed anybody else should have the complete copy of the RRO as made by the Court of Appeal. So we'll make sure that that's available, if that's all right. We're sorry that that there are a couple of paragraphs missing on the copy of the files, but that's a very small matter. And may I just ask the court about the order that we asked for this morning in relation to the selected documents, whether that's confirmed?
I was coming to that, Ms. Rogers. In order to avoid rising, unless either of my ladies has any points they wish to make either on the order we were asked to make this morning or on Ms. Twait's request, and I'm looking for visual signs that they have any objections, and if they don't, we will make that order and we will give Ms. Twait the permission she seeks, but subject only to disclosing the final and correct version of the reporting restrictions order. And I would be grateful if we could be provided with that as well. So in those circumstances, it only remains for me to thank all counsel, juniors included, and the solicitors who've appeared. It's been a very interesting argument. We will take time to consider our judgments. We'll hand them down in the usual way. And when we do, we would like textual only corrections, please, in the intervening period before hand down, and we would ask you to agree an order and the costs, if any, consequences of the judgment. And if you're unable to agree, we will deal with those matters in writing. And if you can't agree the order of any writing, which I'm sure you will be able to, we will give directions in writing. There'll be no need for any attendance on a hand down. Thank you all very much.